VO commentary. We're jumping straight into the deep end of a legal nightmare. Meet Brianna Mitchell. She's facing a manslaughter charge of driving a getaway car in a deadly shooting. But as you're about to see, her day in court is anything but standard. We've got drug tests, grieving mothers, and a defense attorney about to get absolutely shredded by the prosecution. Buckle up.
I'm trying to figure out what is her mental state. Why is she doing this? Why was she a part of this? I've released from prison, and at some point you will be. Do not go up to the house acting as though, here I am. Let me put my rules in place and revoke, sentence you to 10 years in the prison, taking consideration 2000.
Never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I got some things to say about that, but go ahead. Because and Mr. Doss, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other.
I was using it as an education piece.
So you just made it up?
No, I didn't.
Okay, where'd you get it from?
I don't recall.
And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level.
Brianna Mitchell had driven the vehicle when Daniel Jimenez shot and killed the victim in this case, Daniel Sinfield, a gentleman in his late 30s, early 40s, on January 2nd, 2016. It appears that this was stemming from an earlier disagreement between the other suspect in this case and the victim, Mr. Sinfield, where Sinfield had actually fired a weapon in the general direction of Jimenez, the suspect. Later, a couple of days later, the suspect engaged the help of this other suspect, Mitchell, in driving him over to a residence where Daniel Sinfield was located. Sinfield was out in the front yard doing some work on his car when the vehicle driven by Ms. Mitchell drove up to the victim. The suspect in the case, and the other suspect in the case, Mr. Jimenez, actually leaned out the window and shot the victim one time, and he died there on the scene. The two suspects in this case, Jimenez and Mitchell, both actually went to federal prison for several years on an unrelated drug charge. Ms. Mitchell just got out of federal prison this past week, and she and Mr. Jimenez were both indicted for the murder case. The other suspect in this case, Mr. Jimenez, is due to get out of federal custody in 2021, and he will also face this murder charge as well once he gets out of federal custody.
VO commentary, 2 to 20 years. That's the spread for manslaughter in Texas. Notice how the judge is trying to gauge her mental state here. Mitchell claimed she was scared during the shooting, but the court is looking at a pattern of behavior, drugs, CPS cases, and a history of federal prison. Is she a victim of circumstance or just a really good actress? Drop your theory in the comments.
Did you understand the state is proceeding on the lesser included offense of manslaughter? The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Are we proceeding with sentencing or no?
With state waives PSI, excuse me, state 2. Defense waives PSI if that's okay for court.
All right, state.
That's fine, Judge.
All right. Defense, anything you want to say on behalf of your client?
Yes, we just ask that you follow our plea bargain, please.
All right. Someone want to tell me why did this happen? Counsel, Ms. Mitchell. I'm trying to figure out what is her mental state? Why is she doing this? Why was she a part of this? I've read the police reports.
Your Honor, I think. Are you asking why she was a part of the offense?
The offense, yes. I mean, I read the police report. I always want to know, what were people thinking?
I don't know. I was scared.
All right. If you drug tested today, what are the results going to be?
I'm clean.
All right. Have you ever used drugs in the past?
In the past, yes.
What have you used?
Marijuana, meth, and shrooms.
All right. And this CPS compliance, is there an open CPS case?
Yes, Your Honor. She is in compliance as we speak.
How old are your children?
Kaylin, she's 11 months.
You only have one child?
Yes, Your Honor.
One of my twins passed.
Okay. All right, the court will sentence you then to 10 years in prison, suspended and probated for 10 years, $1,500 fine, probated. But if CPS, Mr. Piddle, and probation, I don't want to double anything that CPS is doing. So if CPS is providing her UAs, then that will be acceptable to the court. Are you employed?
Not currently, no.
How are you supporting yourself?
Well, my family's been helping me out.
How old are you?
I'm 28. I just lost one of my twins, so I've just been trying to do the grieving counseling and stuff.
So you're receiving counseling for that?
Mm-hmm.
All right, I'm sorry that happened. All right,
sorry, Judge.
No, go ahead, Mr. Piddle.
She's done a parenting class through CPS, but she'd be glad to do one again through court if you have it.
No, she'll just need to provide proof of that to probation. All right, this is what the court is going to do. As previously stated, sentence you to 10 years in prison, suspended and probated for 10 years, $1,500 fine, probated, CPS compliance, parenting classes, the UA hotline, proof of employment within 60 days. There's to be no employment as a home health care provider or minor. And if there is a counselor, Mr. Piddle, who says that at this point in time, she's not able to work because of the tragedy, they'll need to provide proof of that to probation. We're going to want field visits 2 times per month, random. There's to be regular reporting by Zoom or in person. Why won't you move that? Yeah, but you keep hitting it. He's going to destroy things back here. All right. Probation, is there anything else that Ms. Mitchell needs?
No, ma'am.
Ms. Mitchell, is there anything else that you need from the court in order to be successful?
No, ma'am.
Just one more thing. Her significant other's mother lives down the valley and she's in hospice care. Would you like me to submit a motion for her to go down there for that? Or?
Do you have any objections to her being allowed to visit someone in hospice care, Mr. Nisbet?
No, Kelly, refresh me. She's been on tracking with the permission to go to the hospital appointments and everything like that? Yeah, no objection, Judge.
All right, then there'll be no objection to that. Rebecca, she will be allowed to travel to visit the person who's in hospice care. Mr. Piddle, you'll just need to make sure that you provide proof of that to probation.
And then lastly, the court wish for me to submit a motion to remove GPS, or would the court wish to stay on there a little bit longer?
Mr. Nesbitt, are you okay with removal of GPS?
Yep.
Okay, then GPS will be removed. But even though you're traveling, you'll still have to let probation know where you're traveling.
Can't leave the county.
And I'll order GPS removal.
Thank you, Judge.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Mm-hmm.
All right, we can go off the record. Ms. Mitchell.
VO commentary. The judge just gave her a massive break. 10 years probation instead of 10 years behind bars. It's a get out of jail free card with a very loud warning attached. Start making better choices or you'll find yourself in prison. Well, keep that quote in mind because in the legal world, foreshadowing is a very real thing. Let's see how long this fresh start actually lasts.
You're going to have to start making better choices in your life. Otherwise, you may find yourself in prison. Do you understand?
Mm-hmm.
All right, I'm going to send you to breakout room number 3, Mr. Piddle. Mr. Piddle, I'm going to need you to be patient in breakout room number 3 because I have another plea for probation, and then probation will move throughout the rooms.
No problem, Judge. Thank you.
Okay. Who has Regina Hendricks? Court is going to call 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Pretty Starks.
Defense.
The attorney record, Monica Guerrero, covering for Ms. Guerrero, Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the case of Monica Guerrero?
That's right.
All right, I'm gonna need you to speak up, okay?
Yes.
All right, are you Brianna Mitchell?
Yes, ma'am.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right.
VO commentary. And there it is. Less than a year later, she's back. This time, it's a motion to revoke. She didn't just fail a drug test. She caught new charges, possession, evasion, and false ID. She just traded her freedom for a 10-year ticket to the TDCJ. This is the moment where the grace of the court officially runs out. Total system reboot in 3, 2, 1.
Yes, Judge. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True. Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. We'll waive the other violations.
Any objections to the state's waivers?
None.
All right. Did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in the TDC. In addition, Judge, will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the
I may have put the case in TIC instead of the NPR. That's my mistake.
Yes. No, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
No. And if I may put something else on the record, Your Honor.
Yes.
This offense was created during a time where Miss Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Bexar County time.
So you're asking for credit from April 18, 2016 to April 13, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18, 2016 to April 13, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right, was this case pending?
I can check one moment, Your Honor.
Okay, so that's what I want to know about that. But with regards to the February 18 to 2020, I'm sorry, February 18, 2022 to April 13, 2022, this was pending, correct?
Yes.
All right, so she will definitely receive credit for those dates. I just need to check on the April 18th date. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer says.
Okay, so we can go back on the record for now. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692652, 692653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18th, 2022 to April 13th, 2022. Is there anything else from either side with regards to sentencing?
No.
For some reason, there's no affirmative finding on this of a
On the
deadly
original.
weapon. Yes. Let me see something, just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. All right. Yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun. But that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am. Let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. All right. Good luck to you.
Thank you.
Thank you.
Checking in on Charles Jones. I got your
Who's here on
behalf of Cyrus Abadi explaining to me, right? Cyrus, please speak. Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
A few things to put on the record. I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or
VO commentary. Okay, the vibe just shifted. We're moving from the Mitchell case into a full-blown attorney cage match. The prosecutor, Marie, is accusing the defense counsel of gender-based attacks and baseless accusations. This isn't just a legal disagreement. This is professional beef caught on camera. If you think your office Slack channel is toxic, wait until you hear this.
whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor. Thank you for the interview. So I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I got some things to say about that, but go ahead. Because and Mr. Doss, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel now, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything. I think I in this situation have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I haven't done, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Douse to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that. But this is the part I'm not concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get—
Are you talking about what, I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the response, in the reply. Specifically in paragraph 5. My hope is that counsel, the passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit here and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with him. So that might be something he might want to consider. And you're not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that. Thank you.
As to that issue, and I great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When and let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, you know me, I'll just be blunt. I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Dawson.
Thank you. This is not personal, Judge. This is professional. What I have put in writing and submitted to the court.
No, Mr. Duss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that
VO commentary. The judge has seen enough. When a judge says, "I expected better from you," that is a judicial equivalent of a finish a move in Mortal Kombat. He's not just ruling on the law. He's schooling the defense on basic courtroom ethics and the rape shield statute. It turns out, "I'm an honest man" is a tough defense to use when the judge has 25 years of experience seeing right through you.
I'm taken back by what you put in and that I expected better. You can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Barr at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say, all the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. You say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the barn or the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now, what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was, in a way, misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the long-standing practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Doss, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Doss, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
But I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
if what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law says. That's what the court rule says, not with the defendant. That is not what the rule says. So, if I can go back once more. The very core item that's at issue is whether defense counsel, before exam, needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay. And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis.
Maybe that's the reason you wear the robe and you don't.
All right. I did submit in writing what I know the law to be and stand by that.
Anything additional, Mr.
At this point, Roger.
Right. This court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
Madam Prosecutor?
I'll waive opening argument.
Okay, certainly. We don't need any. Are you ready to proceed?
Yes, Your Honor.
Okay. You may call your witness.
I'll call Deputy Raymond to the stand.
Good morning, sir. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief? Thank you. Have a seat. Would you state your name for the record, please?
Deputy Jesse Raymond.
And spell your first and last name.
JESSERAYMOND.
All right. Ms. Stoll.
Deputy Raymond, where are you employed?
St. Joseph County Sheriff's Office.
How long have you worked there?
I was just under 6 years.
What do you do?
Primarily now I'm covering complaint vehicle, and I take complaints on the road. I also conduct traffic stops.
Do you have any other experience in law enforcement?
Outside of the sheriff's office, no, but I do have other assignments.
Were you on patrol on July 25th of 2025?
Yes, sir.
What shift?
I was on the day shift. I was assigned to the traffic unit.
What was the general location where you were at?
I was traveling southbound on 131. I was south of Three Rivers. I was just approaching Drummond Road.
Right, did you see something that caught your attention?
There's moderate traffic that day. I noticed two vehicles that were very close together.
Could you describe the vehicle that was following?
I don't know.
What did you do after that?
So I had my radar unit activated. I clocked the lead vehicle going approximately 60 miles an hour. I saw the following vehicle was traveling quite close as they passed by. I estimated to be about a car length behind. I turned around at that intersection and it took me about a half mile to catch up. I caught up to him just before Gleason Road where I conducted the traffic stop.
I'm sorry, forgive me, I'm a little hard of hearing. I didn't catch the tail end of what the witness just stated.
And you caught up half a mile at Gleason Road, and then you said something else.
That's where I conducted the traffic stop,
Okay.
south of Gleason, northbound.
Thank you.
And then what did you do after that?
I made contact with Miss Adair. I explained for the traffic stop. Got her license, registration, insurance, and issued a citation.
Is Miss Adair in the courtroom?
Yes, she is.
Could you describe something she's wearing and point her out, please?
She's wearing gold frame glasses and a black shirt.
Let the record reflect that the officers identified the defendant.
It may.
And then did you write Miss Adair a ticket?
Yes, I did.
What for?
For following too closely.
In your experience, was that a reasonable length to keep?
No. I have considerable experience, particularly with traffic crashes where there's rear end collisions. Almost all of those cases, it's a matter of either following too closely or they're unable to stop in a short period of distance.
Objection. I don't think there's a foundation laid for his expertise as being an expert with traffic crashes.
Well, all right. We can establish that. He indicated he'd been an officer 6 years and then traffic enforcement. Madam Prosecutor, would you inquire further about his qualifications in this area?
Deputy Raymond, do you have any sort of special training or experience in traffic accidents?
Just academy training and then routine experience with traffic crashes. I respond to and investigate crashes as a traffic unit, also as a complaint deputy.
How often do you respond to these accidents and complaints?
I would say on a weekly basis over the last 5.5 years.
How many citations do you think you've actually written?
I couldn't give you a number.
Over hundreds. This is a civil infraction, and he's given his opinion regarding this circumstance. I think he's qualified in the context of a traffic enforcement officer, certainly not an accident reconstructionist or anything, but I'll allow the testimony regarding his opinion about why he wrote this citation.
Thank you, Judge.
You said that you were traveling on US 31 southbound?
Objection, yes, and answered.
We're just getting back into it. Yeah, it's 131. Go ahead.
Where were you located when you stopped the defendant?
We were on US 151 traveling northbound just south of Gleason Road.
In what township?
That's Fabius Township.
In St. Joseph County, Michigan?
Correct.
Thank you. Nothing further.
Morning, Deputy. I'm going to ask you some questions. If anytime during me asking the questions, if you don't understand or it's not clear, feel free to ask me to clarify. Deputy, you testified that you were the one who stopped my client, Miss Adair, correct?
Yes.
Okay, so you recognized her?
Yes.
Okay, but didn't you just testify you didn't know what kind of car she was driving?
Correct.
Okay. Would it help if I showed you the ticket to refresh your recollection?
Yes.
Okay. May I approach, Judge? Yes. For, I guess, the juror. Let me know when you're done looking at the ticket. Did your memory refresh?
I have the citation for a 2012 Toyota. I don't remember the model of the vehicle. I do remember the Indiana registration.
Would you disagree with me if I told you it was a Toyota Prius?
No.
Okay. So when you testified for the people, you stated that you were going in the opposite direction, right? And you just testified that my client was driving a Toyota. Do you know what the vehicle was that was in front of her?
I don't.
Okay. Would you have any reason to doubt me if I said it was a GMC pickup?
No.
Okay. But you did catch the distance between that vehicle and my client. Okay. And you remember that there was one car length. Okay. Did you provide any video recordings to the people? Like body wear cam or dash cam?
I did not. I don't know if my clerks did or not.
Okay. So would it surprise you if it was provided? Okay. And do you recall what you said to Ms. Adair when you approached your vehicle?
Yes, I do.
Can you share with me what you said?
Yeah. So I asked her for her license registration, which she provided me. I informed her that she was following the vehicle in front of her too closely. I told her that they were traveling close to the speed limit, and given that speed, that was too close to be following the vehicle in front of her.
Would you doubt me if I just stated that you stated at the time that the courts have found that you need to be traveling one car length per 10 miles per hour?
I did say that to her, not as a...
What authority are you relying on for that statement? When I say authority, legal authority.
I was using it as an education piece.
So you just made it up? Okay, where'd you get it from?
I don't recall.
Okay. So you read this, you're familiar with the statute, right?
So,
and what does it use?
You must be no closer than reasonable and prudent to the vehicle.
Reasonable, prudent person. Are you familiar with, you're familiar with the State of Michigan Secretary of State, right? Okay. Are you familiar with a publication that they put out called What Every Driver Must Know?
I'm familiar with it. I don't recall any text in it.
Would you doubt me if I said it doesn't say anything about a car length for every 10 miles? Okay. I'll help you. It doesn't.
Objection, Your Honor. Your side.
Well, the officer accepted the answer he accepted that he is familiar with that publication, which every Michigan driver has to review before they take their driver test. I'll allow it. It's not damaging, really, either way.
As a matter of fact, well, let me back up. Would you doubt me if that publication takes into account what is considered the reasonable distance between two traveling vehicles? Okay, would you doubt me if it says that you need to take into account the vehicles, the drivers, condition of the road, weather conditions? Okay. You interestingly didn't testify to, you talked about moderate traffic, but do you remember the weather conditions that day?
Yep.
What were they?
It was a clear day, dry roadway.
There was no rain, was there? Mm-hmm. Okay. And do you know that you recall on the side that my client was driving on, how many vehicles were traveling? About the time that you witnessed these two vehicles going down that road. I'm sorry.
Specific number, I don't recall.
If I played the video, would you doubt me that it was just that vehicle and her vehicle? Okay. As a matter of fact, on your side where you were traveling, where you said you witnessed the cars traveling too close to each other, there was a lot more traffic, or as you said, moderate traffic. Would you doubt me? Okay. Did you notice that, or do you strike that? When you came up behind my client, did you notice the, I guess, double lines, dotted lines in the roadway?
At the location of the traffic stop, I believe it would have been a double line, but I don't think so.
You don't know if my client was attempting to pass that vehicle either, do you? You didn't ask her, did you?
I had turned around and followed the vehicle for approximately half a mile.
I'm gonna inject myself a little bit.
I'm sorry, Judge.
I'm gonna inject myself into this to add some context. On the map, run 131 looks like it runs flat, straight, north and south. Is that correct?
It's a relatively easy section.
Well, that's what I'm going to ask. It's actually on what's known as the Big Hill. Is that correct? 131 and Drummond Road is on what's known as the Big Hill between Three Rivers and Constantine. Is that correct?
I'm not familiar with the term.
You're not? Okay. Anyway, it's a big hill. And it's common, well, maybe I'm too old, but there have been many, many accidents there. One time we had two drunk drivers hit each other on the big hill and they were both killed. Anyway, was this on the hill?
A portion of the observation period was, yes.
Okay. So this is a big hill. And so they're both going up the hill at that point. Is that correct?
They had gone up the hill and I stopped them after descending down.
Okay. All right, thanks.
Anything else, Judge? I'm sorry.
No, I don't know if you've been there, but
Unfortunately, I'm not familiar with.
At any rate, it's on the big hill, and apparently we're headed uphill, and then he stopped them as they headed down.
If I played the video of you turning around, well, is your video activated? It's not running all the time, right, Deputy?
It's running, but it only pre-records a certain time frame before it's activated.
Okay, because it was shared with me, the video, but it wasn't shared of, I guess, where you felt that the car lanes were too close. But I got a video that shows you stopping the vehicle. I don't know if it would help the court making a decision if the people don't object. I mean, I'll play the video.
Well, I was hopeful they would play it.
I'm kind of a little surprised, but they can present their case any way they want.
Yes. Yeah, you can present the video to the officer. We have a way to do it.
I'm not technical. I mean, I could set this up there and you can look at it.
Well, we have a way to play it on the big screen, although I'm not sure any of us are technically adept enough to plug it in.
And just so I'm making a record here, Your Honor, the video that I have that was shared with me just reflects the stop. I don't think it actually reflects what the deputy testified to what he witnessed when he was coming the other way. So I don't want you to go through all this laborious effort.
So it doesn't show the actual.
It shows him doing a U-turn and coming up behind the two vehicles, my client being the closer one to him. It doesn't show what what Deputy
Raymond
James testified to what he witnessed when he was coming the other way. That's why I asked him about if his camera was activated at that time. If there is footage of that, it wasn't shared with me.
What are we seeing here, officer?
So I believe at this time I had already turned around. I was traveling northbound.
Okay.
Like he said, you can't see in the video the time that they initially passed me due to the latency in the activation recording.
So you're going down the hill at this point. Is it alleged that she's followed too closely at this point?
Yes.
Yes?
Traffic stop. Civil infraction. A traffic violation. US 131/14 East Township.
So this, you can't, I don't believe you can hear anything. The body work camera, this is just a stop, Judge and Madam Prosecutor. If you want to hear the body wear camera about the car length thing. So this is the stop. The video.
Hello, how we doing? Wonderful. Do you have your license registry? The reason I stopped you and the vehicle in front of you guys were both going about the speed limit. You were right on his tail, so you gotta have a little bit of space off of them. Okay. Rule of thumb, there's not really any number on it specifically. The courts have found that about 1 car length for every 10 miles an hour. So you really should have been 5 or 6 car lengths back behind that at least. So, okay. You got interest in
Okay. Thank you for indulging me, Judge.
Thank you. That certainly didn't translate very well to a live stream, but they could hear it and I could see the video. I didn't see what was going on the way up the hill, but I could see what was going on the way down the hill. All right. Any further questions for this officer?
No. Thank you, though. Thank you, Deputy. Appreciate it.
Ms. Stoll, do you have any further questions for the officer? Do you have any questions for the officer?
No, Your Honor.
All right. Thank you. You can step down. Any further witnesses?
No.
All right. Mr. Spinolio, do you wish to call the defendant?
Judge, if you're prepared to make a decision, and being mindful of the court's docket, if you're prepared, I'll waive presenting my client. I mean, the video speaks for itself. I think that that's what the deputy said.
Thank you. I'm disappointed in that. The prosecutor didn't play the video. Have you even viewed it? Have you seen it before?
I saw it, Your Honor.
Okay. Well, I would have liked to have seen it as part of the prosecution case because she's right on his tail. The video sunk your boat. You're doing pretty good because they hadn't even looked at the ticket or know what kind of vehicle it was, and his testimony was unclear, and it wasn't clear where it was. It's on the biggest hill in St. Joseph County. But you were right on his tail. I don't know where you were going up the hill, but going down the hill right up until the stop, you were right on his bumper. And it's not a place to pass. Passing is prohibited there for quite some time, going up the hill and down the hill. What the statute actually says, the officer says, the rule of thumb is you should give 1 car length for every 10 miles an hour. That is a quote unquote rule of thumb. We've heard it on television commercials and other things. It isn't in the statute anywhere. But what the statute says, the officer quoted it pretty well. The driver of a vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of the vehicles and the traffic upon and the condition of the highway. So this is a 2-lane highway. It's a state highway with a center line on a large hill, and passing is prohibited going up the hill and down the hill. The speed limit there is 55. He testified that he thought the first car, which he couldn't remember what it was, if he looked at the video, maybe he could have discerned it, was going 60. The ticket says she was following lead vehicle, one car length, going 57 miles per hour. This is a civil infraction. You can't go to jail for a civil infraction. And you don't have the right to proof beyond a reasonable doubt. You have a right to proof beyond a preponderance of the evidence, which is a much easier standard for the prosecutor to meet. It means just barely more than the other side. So I was trying to figure this out, but as soon as I saw the video, in my impression, you were too close behind that truck. So I find that you're responsible for following too closely, and I'm gonna fine you $120. You can pay that today, or I'll give you 30 days to pay it if you need it. Or do you want to pay it today, or you want me to give you an envelope to pay it? All right. We don't have enough trials for young officers to learn that they're going to be subjected to cross-examination. And when a competent attorney comes in and asks questions and makes appropriate objections, it's a lot harder than some layperson trying to do the best they can. So the point being, when you come to court, you should review your police report, you should review the ticket, you should review the video. The video should have been presented, but I'm not doing your case. The defendant actually provided it, which gave the court proof beyond a preponderance that she violated the statute, but can't sleepwalk through these. This defendant came prepared, but I did find the violation. So you can go out to the counter, pay the $120. This will go on your Michigan and eventually Indiana driving record. It's not exactly the crime of the century, but you were too close to the car ahead of you, in my view, after watching the video. All right, we'll be in recess.
Thank you, Joe.